So again, welcome to HR Assured's webinar for the Collective Wellness Group. It's just an introductory webinar to sort of go through a few things that are specific, obviously, to the fitness industry, as well as providing you sort of an outlay of the service that we can provide here. So my name is Sean Holloway. So I'm a workplace relations consultant. So I'm one of the people you'll speak to when you call through on the telephone advisory service. So obviously we do HR consulting for a number of franchisors here. And we're just going to go through a few things today. So this presentation is essentially going to go through sort of the basic legislative requirements under the fitness industry. And in addition to that, we're going to look at sort of what HR Assured can offer you. So what are we going to go through today? Well, the first one is who are we? As I said, we're going to look at a legal framework. Look, I'll try not to make it too boring. I understand that 4 o'clock in the afternoon talking about legal things are not the most exciting things, but we'll try to make it relatively interesting. We're going to go through sham contracting, which is quite significant in relation to obviously the fitness industry, as well as looking at the scope of both the telephone advisory service and navigating the HRA cloud. So who are we? HR Assured is part of the FCB group, experts in workplace law, HR consulting, technology, work health and safety migration, with over 20 plus years experience working with franchise groups and industry associations. What we focus on in providing is a holistic management solution, and how we provide that is through telephone advisory service, and in conjunction with that, we also provide the HRA cloud, which is sort of an online platform which will assist you with everything. Okay, so again, HR Assured is made up of FCB Workplace Law, FCB, and the Enable HR, which is the online cloud we're going to get into a little bit later on. What we're going to start with is looking at some of the challenges facing the franchise sector currently. So this is just a quote from the current Fair Work Ombudsman, Natalie James. And I'm just going to read it out. For those who are underpaying workers, failing to keep proper records, or coercing workers to pay their wages back in cash, we will not hesitate to deploy the full set of tools in our toolbox, including using the new examination powers and seeking maximum penalties from the courts. Essentially, and I'm sure as most of you know, there were some quite significant underpayment issues with a few franchisees. Probably the most famous one recently is 7-Eleven, and this is actually a direct response to that. And as a response to that, they've actually brought in new legislation, protecting vulnerable workers legislation, and the Fair Work Ombudsman has made it clear that they're going to go out and they're happy to prosecute people and actually take them through the media if it's necessary. So it can be quite damaging to the business. Now, I don't want to be all doom and gloom and try and scare everyone, but I think it's also very clear that people should realize that there are some significant risks facing the franchise sector currently. So one of the primary things that have come up from the Working with Vulnerable Workers Bill, Protecting Vulnerable Workers Bill, is this increased compliance regime. So essentially, it's these new laws that have come in that have provided Fair Work with new powers and new ways to look at things. And the kind of issues that they're going to be looking at, obviously, are wages and entitlements, but also new obligations on the employer. So new things the employer has to do in regards to employment records, transactional employment issues, which I'll go through a little bit more later on, as well as sham contracting, which is very, very relevant for the fitness industry. So we're going to start by taking a look at the legal framework as it currently stands. So part of what makes this so complicated, unfortunately, is that there is this plethora of laws, essentially, that governs the workplace in Australia. So up the top there, you have the Fair Work Act. You also have multiple discrimination acts at the federal level, so the Commonwealth Discrimination Acts. In addition to that, you've got state and territory legislation for equal employment opportunities, work health and safety. And another thing that we sort of have to deal with as well in this industry is the Fitness Industry Awards. So as you can see there's a lot to actually deal with. And so going through this process, it's important that we can sort of maximize our value by realizing which issues you can come to HR Assured to help you with, and make sure that we're limiting any risks that you and your business are actually going to enter into, because it is a very challenging situation. So when we look at the legal framework, there's two primary considerations essentially that you'll have to deal with, and they're essentially what you have to do under the Fair Work Act, which outlines your minimum employment standards. It's got specific keeping and payroll, as well as contracting provisions, trying to determine whether an employee is in fact a contractor or an employee. In addition to the Fair Work Act, you also have the relevant modern awards. So in this case, the Fitness Industry Award, and that's a specific industry award. So it's essentially, it's another set of laws that apply specifically to the fitness industry. And one of the things it does specifically is it details minimum wages for the industry and also outlines the ordinary hours of work employees can work. So the National Employment Standards, this is under the Fair Work Act, and I don't want to get too complicated here, but essentially you've got 10 things here which form what's known as a safety net for your employees, and it's very much designed to protect the employees' rights. So these 10 things, the National Employment Standards that are outlined in the Fair Work Act, outline the maximum weekly hours, which is 38 hours a week, gives employees a right to request flexible working arrangements, outlines your rights for parental leave, annual leave, personal, so personal is your sick leave as well, personal carers leave and compassionate leave, community service leave, so things like jury service, long service leave, public holidays, as well as who needs to give termination, who needs to give notice on termination, both employees and employers, and the Fair Work Information Statement. The other thing the Fair Work Act outlines is employee protections. And there's two primary protections that you have to deal with. Your first one is, you have two primary protections you need to consider. Your first one is your general protections. So general protection is where termination is based on either discriminatory grounds or because an employee has exercised a workplace right. So without getting too complicated, if an employee, for instance, takes sick leave and has a doctor's certificate, has access to sick leave, they take sick leave, and you subsequently choose to terminate their employment, there's a very, very strong protection in the Fair Work Act that stops employers doing that. And it can be quite costly. So if you ever have an issue with employees who are calling in sick, or you're not sure how to deal with annual leave or wage-related requests or anything like that, we very much advise you to call through to our telephone advisory service, and we can take you through each step to deal with these issues, because it can be a tricky area. The other really big area under the Fair Work Act is the unfair dismissal legislation, which essentially sets out a minimum employment period, which is 6 months for small businesses, so less than 15 people. My apologies, 12 months for small businesses, which is less than 15 people, and 6 months for a large business, which is 15 or more. And if you've got an employee who is working for your business for longer than the minimum employment period, and the termination is harsh or unjust or unreasonable, so there's not a valid reason for the termination, then there is some risk under the Fair Work Act for an unfair dismissal. So again, it's one of the major things that we provide on the telephone advisory service. If you have to, for whatever reason, go through a process where you'd like to terminate an employee, always give us a call first, and we can sort of provide you with the best practice advice to limit the risk. Again, we're just looking at limiting the risk for your business. Another area of quite significant importance is record keeping and payroll obligations under the Fair Work Act, and these are one of the things that have changed quite significantly. That have changed very significantly since the Vulnerable Workers Bill came in. Now, essentially, employers, they have a job. They have a job to make sure they keep accurate records and that they do issue pay slips to each employee. The challenge with the Vulnerable Workers Act now is what's actually happened is there's a reverse onus of proof. So that means if an employee was to subsequently make a claim to say, I worked 40 hours last week and I'm entitled to overtime, and the employer can't provide payroll records, then the courts and the commission are going to believe the employee. So the job is now actually on the employer to show that they have these pay records and they have pay slips, just to show that they have been adhering to their obligations under the Fair Work Act. It's a very high standard now. And so some of the records that you need to consider when you are issuing these pay slips, and some of the records you do need to keep, are these records. Now, they need to be kept for 7 years. And obviously you'll have things like the employee's name, but you also need to have the employee's status, so whether they're permanent, whether part-time or full-time or a casual employee, what rate they're being paid at, the number of hours worked, any leave taken, all of these things you want to outline in your, all the things you want to outline in your payslips. And again, this is something that's really important to keep on top of because of that reverse onus of proof now. Now, a breach of some of the things we've talked about, so the Fair Work Act, unfair dismissal, general protections, all those 10 things under the National Employment Standards. A breach under that is what's known as a civil remedy provision. So, payments of wages, general protections, employee records, pay slips, even contravening, so even breaking one of the laws, let's say, of the modern award amounts to a civil remedy provision. What that means is essentially you can be fined if you break one of these things. Now, the fines are $12,600 for the individual and $63,000 per contravention for a company. Now, they are the maximum fines. It's important to recognise that obviously they are the maximum fines, unless it's a serious contravention, which is a serious contravention essentially means you knew what you were doing wrong and you continue to do it. But even if you don't know what you're doing is wrong and you just make a mistake, these are the maximum penalties that can be imposed. But what's very important to notice is so to say it's $12,600, it's $12,600 per contravention. So every time you break one of these laws, for instance, you're potentially liable for $12,600 every time. Again, I'm not trying to scare you, and again, that is absolutely the maximum penalty, but it's just trying to outline some of the quite challenging risks that face, businesses in Australia under Australia's current workplace laws. Now, as everything I've discussed essentially up until now is the Fair Work Act. So that's sort of half of your laws that you need to follow, essentially. The other half is the Modern Award. Now, there are 122 industry and occupation awards. Now, generally speaking, if you're in a gym with trainers and even reception staff, administrative staff, but in the gym, they're going to be covered by the Fitness Industry Award. In very, very, very rare circumstances, if they're doing a job that's completely outside of the fitness industry, they may not be covered by this award. And again, as experts in the area, we do advise you to call the telephone advisory service if you have any questions about an employee, about the correct classification of an employee, or whether they are covered by the Fitness Industry Award, because that's the sort of information we'll be able to provide you. Now your Modern Award covers your coverage and your classification, so what employees are covered by the Modern Award. It also covers your consultation requirements. So what you need to do when changes happen in the workplace, say for instance if you're making an employee or a bunch of employees for that instance, if you need to make them redundant, you do have some obligations to actually consult and discuss the changes with them. Covers your rostering, your hours of work and your overtime, so when and how overtime is going to be paid, as well as how the part-time employment relationships are meant to look, and your penalty rates as well. So for all your minimum wages, it's going to be reflected in this Modern Award. So the Fitness Industry Award, again, is specific to the fitness industry here, and again, it's going to cover all of those sorts of things that you'll be dealing with in the fitness industry. So we're going to go through some of those things now. We're not going to go into a lot of depth, and if it all goes over your head a little bit, don't stress. If you have any questions, you can of course type them in that chat box in the bottom right hand corner. But as an alternative as well, you can call through our line anytime. We're more than willing to discuss this in a little more detail and perhaps a little more clear. So what we have is the coverage. So the Fitness Industry Award covers the fitness industry, surprisingly, and the employees who are classified in this award. One of the things that it does extend to is any administrative or operational staff or support to a fitness center. It specifically is to a fitness center. So for your Anytime Fitness, your Extend by Your Orange Theories, this is also going to cover them. Maybe a little bit different from Massage Envy. They'll be covered under a different award, but for all intents and purposes, a large amount of these provisions are the same. Now, if you're from a Massage Envy franchise, just keep in mind that the classifications and the obligations under the awards may be slightly different. And if you have any questions, just call on through. So the fitness industry is actually defined in the award as well. So it includes the operation of fitness centers, fitness services, and group fitness organizations. And you see those 3 points. It's going to cover your Orange Theory, your Anytime Fitness, your Extend Bar as well. So your classifications. So this is the basic bread and butter of your modern award. Essentially, every award has a bunch of levels and some descriptions on how you're going to classify your employees. And essentially, you're going to look at what job that they're doing and what level that would be appropriate. So for a level 1, you're looking at an entry-level role. They've just got general basic duties, but can include basic administration and basic cleaning. Your level 2 is a level 1 employee who has completed 456 hours, which is 12 weeks or 3 months, but is still going to be very much working from instructions, procedures, under direct supervision. They're not going to be doing anything. They're not going to be doing anything, with a lot of discretion or exercising their own judgment. Your level 3 is an employee who works under general supervision, so your supervisors might be checking in from time to time, has clearly defined areas of responsibility, and they can, in certain circumstances, supervise level 1 and 2 employees where requested. A level 4 is again going to work under a little bit less supervision and will be required to exercise that initiative and judgment while they're doing their day-to-day duties. Level 6 predominantly is going to actually be supervising your level 1 to 5 employees and overseeing your day-to-day activities and operations of the business. And your level 7, bear with me just one sec. And your level 7 essentially is going to be, so I've just got a question here asking if direct supervision means someone physically watching them work. That's what direct supervision means, yes. You need to have someone there physically supervising them, not actually next to them, but within the building, within the building, supervising them. When you get to that more general supervision, or especially when you get the limited supervision, they can obviously work a little more autonomously from time to time. But when you're at those lower levels with direct supervision, they need to have a supervisor there who they can ask questions to, who they don't need to make any decisions or exercise any judgment. When they get a question and they're not sure of the answer, they can turn and ask their direct supervisor immediately. And so again, just back to your level 7, supervising, training, and coordinating employees generally will possess specialist knowledge, such as a trade qualification, and exercises substantial responsibility and independent initiative. I mean, that's a very high level, your level 7 there. Now, there is another stream for all intents and purposes under this award, and it's the trainer's stream. So a level 3 and a level 4A, specifically if you've got a level 3 qualification or a level 4 certification, you'll be a level 3 or a 4A depending on the qualification. There's 2 steps for this. Firstly, you need to have the qualification. The second thing you need to consider as well is they need to be utilizing the skills from that qualification. So it's not enough if your gym receptionist, for instance, has a Cert 4 in fitness, because if they're not doing personal training and they're not doing anything that from the knowledge that they derive from that Cert 4 or Cert 3, then they're not doing the duties that are consistent with a level 4A. Likewise, the level 5 holds a diploma level qualification, and it utilizes skills and knowledge derived from that qualification. Generally, you're looking at your fitness trainer and fitness specialist. So this is a sort of a broad overview and a great place to start if people aren't sure with where they're going to go with classifying their employees. Now, again, we always advise to call in if you're not really sure, but this is a great little slide. Just as a very quick aside, I will actually be emailing these slides to all the people who attended the webinar after this webinar today. So you will have these slides as access as a reference to go through a few things just to make sure, and if you do have any questions, to sort of refer back to. But anyway, looking at these classifications, as you can see from the top, you've got your level 1 to 7. And basically there's 3 primary factors that will be a consideration as to whether they're, how high they're going to fall essentially along this line here. And it's supervision, so whether they're clearly under direct supervision or they work completely on their own, how much responsibility the employee is expected to have. So if they're coming in, there's always somebody there. They've always got somebody to ask what to do. They get very, very clear directions. They're not left alone in charge of the gym. or a class on their own, then obviously they've got very minimal responsibility. Whereas if they're running the day-to-day operations of the facility, they've got quite substantial responsibilities. The third one is your experience. So generally speaking, people at those lower levels are going to be relatively inexperienced and will maybe receive some on-the-job training. And then as you move up, you're going to get the more formal qualifications. So your Cert 3, your Cert 4, your exercise physiologist once you get up to those bachelor degree qualifications, all those specialist knowledge. Now, there are some examples here, and there is some flexibility in these awards, but generally your receptionist is going to be a level 2, a gym manager is a level 6, and a center manager is level 7. But it really does depend on the facts and the specific, essentially the specific jobs that they're going to be doing as an employee. So the other thing, or another thing that the award essentially outlines as well, is the hours of work. So what every award does is they go, these are the regular hours of work, and anything worked outside of these hours will be attractive penalty rate. Typically an overtime penalty, but in some other circumstances a different penalty. So these are the primary provisions of this award, and it's a little bit different to some of the other awards that you might have looked at some point. But on average, and this is a national employment standard, it's a 38-hour working week for a full-time employee. This can be averaged over a 4-week period. So if you have ebbs and flows in the business, provided there's a 4-week roster, you can average a full-time employee over 4 weeks. So they can work 44 hours one week and then 30 hours the next week. Hours may be worked over any 5 days of the week. So essentially that means if they worked more than 5 days, in a weekly period, there's a provision for overtime. 10 ordinary hours per day, so more than 10 hours a day, again, will attract that overtime penalty. So your span of hours, under the award is 5 a.m. to 11 p.m. Monday to Friday and 6 p.m. to 9 p.m. on a Saturday. So your span of hours essentially is what can constitute ordinary hours. So again, anything outside of this is going to attract that overtime penalty. You also have a minimum engagement period for any casual or part-time employee, and that minimum engagement period is 3 hours. Now, that does come with some exceptions, but as a general rule, it's good to realize that if you're going to bring someone into work as an employee, the minimum period is 3 hours. Now, casual employees, which are classified as a trainer and doing work as a trainer, may be engaged for a minimum of 1 hour. That is a very unique provision, and it's an exception in the Fitness Industry Award, but something that I think it's important for the franchisees to know, because it is quite significant and can help with some of those issues with bringing casual trainers into the fitness industry. So just looking at rostering, again, set out in the award, generally speaking, roster changes for permanent employees require 7 days notice, and that's both ways, either from the employee to the employee, so from the worker to the boss or the boss to the worker. In emergencies, so such as an unexpected illness, the roster can be changed on short notice, generally 48 hours. Also, when you're looking at meal breaks, an employee, so a worker needs to have a meal break no later than 5 hours after completing work. So if they start work at 5 a.m. in the morning, they cannot have a meal break past 10 p.m. 10 a.m. Sorry. If they do have a meal break past that, they actually get paid double time until they get a break, or they're entitled to the double time penalty until they get a break. So it's important when you're rostering on your employees to recognize that they need to get this break, and it's a minimum 30 minutes, a maximum 60 minutes. They're also entitled to a 10-minute paid rest break for every 4 hours of work. Something that's quite unique to the Fitness Industry Award as well, and it's to help with sort of the nature of the fitness industry, is the broken shift allowance, or the broken shift, which does attract an allowance, but we'll go through that a little bit later. So broken shift, there are just some requirements. So it's where an employee comes in, maybe works from, 9 till 12 o'clock, and then comes and works from 5 till 7 p.m. in the evening. Now, a shift may not be broken into more than 2 parts, so it has to be a genuine broken shift. You'll have that break in the middle, which you'll need to have if it's longer than 60 minutes, because that's the meal break, but it cannot be broken into more than 2 parts. The total length of the shift cannot be less than 3 hours. So that goes back to your minimum engagement period for your casuals and your part-time employees. So you can have them do an hour and then have a couple of hours off and work another 2 hours. But the total length of the shift that they're actually paid for, it needs to be that minimum of 3 hours. And the splits of the shifts cannot go over 12 hours. So for instance, if you have an employee who does work from 5 to 10 a.m. in the morning, they could come in the afternoon and say do from 3 to 5 p.m. But anything after that 5 p.m., because they've started before 5 a.m., would attract that overtime penalty. Just bear with me one second. So overtime, now we're looking at overtime. Overtime is paid, and I've mentioned a few of these things. But overtime will be paid whenever an employee works outside the spread of hours, more than 38 hours per week, more than 10 hours a day, and has less than a 10-hour break between shifts. Now, the penalty is it's 100, from Monday to Saturday, it's time and a half, so 150% for the first 2 hours and double time thereafter. And your Sunday entitlement is double time for the whole time. Now, if you don't get 10 hours off between shifts, and this isn't for a broken shift because that's specifically allowed under the award, but if, for instance, an employee finishes work at 9 p.m. at night and then comes into work at 5 p.m. in the morning, 5 a.m. in the morning, they won't have 10 hours off between that shifts. If you don't get 10 hours off between a shift, you will actually be paid double time for the entirety of that shift. So again, this is another consideration that you need to be aware of when you're going through your rosters for your part-time, full-time, and your casual employees, because it can be a quite costly error. So can part-time trainers do an hour shift? It only applies to casuals. My apologies, bear with me just one sec. Specific provision under the award. No, it only applies to casual employees for your doing a 1 hour shift. But I can check that to clarify. My understanding is currently under the award that it applies specifically to casual employees only. Doing that 1 hour shift, but they can do that 1 hour and then a couple of hours in the afternoon, and that would amount to a split shift, and that might be a way to get around that issue. So we've gone through overtime. So looking at the penalty rate, so your penalty rates here essentially are what are penalties that are paid for specific reasons. So on a Saturday, your permanent employee is going to get 25% loading, and a casual employee is going to get 30% loading. On your Sundays, your permanents get that 50% loading, and your casuals get that 30% loading. And public holidays, all employees are entitled to double time and a half when they work on that public holiday. So allowances, another thing that's set out by this award quite clearly is a certain number of allowances that are required to be paid in certain circumstances. Some of the circumstances where these allowances will be required to be paid are, for instance, where an employee is classified as level 4A or below, if they're in charge of a following number of employees. And this will be generally a very rare situation, but you're looking sort of at the level 3 where it does have that provision to supervise some employees. They'll be entitled to a payment of 61 cents when they're supervised per hour when they're supervising 1 to 5 staff, 83 cents per hour when they're supervising 6 to 10 staff, and then $1.11 per hour when they're supervising more than 10 staff. So meals as well. So when working more than 1 hour of overtime after a usual shift, the employer will need to provide a meal or $11.37 as a meal allowance. Generally speaking as well, this is obviously only occurs when they're required to work overtime. So a vehicle when an employee, so generally speaking as well, for most of the franchises here, your employees are going to come to the gym and run their sessions here. So the idea of an employee using their own vehicle for work is pretty unlikely. But if for whatever reason an employee does need to use their own vehicle for work, then they will be entitled to a payment of 78 cents per kilometre travelled. And then the broken shift allowance. So if you do have an employee who is working on that broken shift, they will be entitled to this additional allowance. So for every day they're on a broken shift, they get $13.05 per day, with an additional of $1.89, which is designed to compensate for excess fares. So first aid, so when an employee is a first aid officer, so when they're first aid trained and they're required to be a first aider on duty, they're entitled to an allowance of $2.46 per day. The final allowance is a little less clear. It's a uniform allowance. It's required when an employee is required to wear specific clothing, so your Extend Bar, branded, or your Anytime Fitness branded outfit. And the employee must be reimbursed for a reasonable cost of purchasing such clothing. Generally speaking, though, this clothing will be provided, which is okay and covered by the award. So we're just going to go through a very basic look at contractors as well under the Fair Work Act. Now, keep in mind this is quite a complicated area, but B, it's not exactly clear. It's a very grey area of law, and so it's worth recognising that. Be aware that it might not make a lot of sense, but I'll try and make it as clear as possible. And ultimately, if you do have any issues, and we understand, obviously, this is a very significant issue facing the fitness industry, so if you do have any issues or concerns at all, be sure just to call us on our telephone advisory service. You can call through to us, and we can discuss this through with you and help sort of protect your business as best we can. And like I say, we try to limit the risk when you are engaging contractors. So just looking at why we use contractors at the start, and in some circumstances, a contractor may be cheaper. Contractors, generally speaking, often, because they're running their own business, they often supply their own equipment, tools, or vehicles. There's a lot more flexibility with a contractor. You also have specialized expertise when you have a contractor. So you're not hiring someone, you're bringing somebody on board to do a specialized skill. You don't need to train them, you don't need to invest any time or effort into that. They step into the business with all these skills. You don't need to worry about any of their leave entitlements. The modern award, for instance, doesn't apply to contractors. You're not responsible for chasing up payments for training sessions. So if your contractor is invoicing their clients directly for their own business, you don't need to act as the middleman. You don't need to deal with the clients. They just chase up their payments from their clients. Some of the disadvantages of contractors, though, is generally because they are those specialized skills, they are more expensive than your employees. They can lack an engagement in the workplace, and this is quite significant because they're running their own business. They're coming in there, and for all intents and purposes, as a contractor, they're doing a job for you. They might not care about the workplace. One of the primary tests as to whether there's a contractor or employee is the amount of control. And as a principal and contractor, the boss in the contractor relationship doesn't have a lot of control. It also limits your ability to actually train your staff. Because they're running their own business, you can't really train your contractors. They provide a service at a certain level, and it's essentially a take it or leave it proposition. There can be challenges in establishing a long-term relationship or reliability, and some contractors can have a sense of entitlement or over-independence. So the biggest challenge facing the fitness industry is distinguishing between what is a contractor and what is an employee. At the most basic level, essentially, there's a list of things that they look at to determine whether a contractor is an employee or a contractor, and these are all factors, as you can see in front of you, that go to that. And if it ever was to go to court, or if the tax office was ever to come auditing, what they look at is they look at the relationship as a whole, and ultimately they determine whether it's an employment relationship or a contractor relationship. A very famous quote from a judge is, "You can't dress a rooster up as a duck and insist everybody else calls it a duck." Essentially, it means if it's a genuine employment relationship, but you try to disguise it as a contractor relationship, that's when you're going to run into some risks. So I'm going to go through some of these factors here and just outline what will look like an employment relationship and what will look like a contractor relationship. So your first one, and quite significantly, is control. So a contractor as an independent contractor runs their own business. An employee works for the primary business. So if you're controlling an individual, telling them the hours that they can work, dictating their rate of pay, things of that nature, exercising a lot of control, they're more likely to be considered an employee as opposed to an independent contractor who is running their own business. And again, we've touched on that. If a genuine contractor is running their own business, so they'll dictate their own hours of work. They'll generally work for a specific task, and it won't be an ongoing arrangement. There'll be an agreement in place as a contractor. They may not be required to wear a uniform because they're running their own business. They don't get paid leave. They worry about their own superannuation and tax. Generally speaking, they'll provide their own tools and equipment. They can delegate. So as a contractor running your own business, if they've got a job to do, say run a training class, so run a group fitness class that they generally do every Tuesday night, but they don't want to do it that week because A, they're on holidays or they just have some other reason, they can just give that job to somebody else. And that's the idea of what a contractor is. They run their own business, they have their own clients, they can move them on. Exclusivity, so if you're an independent contractor, you work for yourself, you essentially choose who you're going to work for. So you could work for, the Extend Bar here and the gym down the road and run your own business in the park as well, doing your 3 boot camps every morning a week. If you're required to just work for one gym, so if they're just working for your Anytime Fitness, it's going to look more like an employment relationship. How much risk is involved in the business? So if you run your own business, obviously, and as business owners, you're all aware, there's a certain amount of risk that's involved in running your own business. And also the method of payment, so whether they're paid an hourly rate and whether they're paid sort of weekly or whether they invoice. So when you look at that, you look at all of those factors, and then essentially the determination is whether they're running their own business or they're part of another business. That's ultimately what the decision is. If these relationships ever go under scrutiny. What we provide here at HR Assured is a checklist that you can go through to identify any risks in your contractor agreements, but also the telephone advisory service where essentially you can call us up and we can discuss the relationship the relationship with your contractors, discuss whether it would be considered, whether it's likely to be considered an employment relationship or a contractor relationship, and try to take some steps to mitigate that risk. So if that relationship ever comes under any scrutiny or the Fair Work perhaps comes looking at the relationship, you can show steps you've taken to ensure that it actually is a contractor relationship. As I have mentioned, it is a very, very complicated area. And so if you do have any questions about this, please call through. We encourage you to call through to the advice plan. I'll give you the numbers for the relevant brands at the end of the presentation. But just call through and we're more than happy to discuss this because it is a complicated issue. So the next issue you're looking at as well is the sham contracting. So this is another risk that comes up in the contracting provisions. So the Fair Work Act essentially sets out a bunch of rules about making an individual a contractor when they believe the person would be more accurately classified as an employee. So the sham contracting provisions is where an employer, and it looks essentially here at the employer, the employee essentially doesn't have any obligations for this. Looks at whether the employer is essentially disguising the employment relationship. So they may be requiring their trainers to show up at specific times, paying them weekly, making them wear a uniform. They have to follow certain programs, so maybe they have to follow like a Les Mills program or something like that. But then they get them to invoice and pay them as a contractor. That's where it starts to look like the contractor relationship is actually disguised a little bit like an employment relation. My apologies. It's where an employment relationship is disguised as a contractor relationship. And the Fair Work Act is trying to stamp this out. Unfortunately, it's not very clear, but I've gone through some of the risks there. Now, this can happen for a number of reasons. It can be because a business is trying to avoid to pay leave or other entitlements. What we mostly see is businesses just mistakenly misclassifying their relationship and didn't have the knowledge. And that's what HR Assured is here for, because we do have the knowledge. We're an area where you can just outsource your HR. So you can just call us up when you aren't sure about a HR or employment relations question, and we can provide you with a little bit of information and guidance on that. It can also be where a business succumbs to pressure. So sometimes individuals want to be engaged as a contractor, or where you buy a new business and the owner just continues with the practices of when you bought that business. Importantly, though, it is unlawful and it can lead to significant penalties. So just a very brief review, and look, I know it's not super exciting, and B, it is a little bit complicated, but a very quick review. Whether somebody's an employee or a contractor, it's a matter of fact. They either are an employee or a contractor. You can't call it something else and make it that. It's important that you review all the arrangements, and we can step in and obviously assist you to review your contracting arrangements here with your current workers to ensure they have been classified correctly. Look, the fitness industry, it's incredibly challenging to have trainers come in and to try and develop those leads and generate their business, whilst on the other hand, trying to maintain an employment relationship. And we do recognise the challenges there. It's unlawful to misrepresent, so it's important to recognise, obviously, sham contracting is unlawful, and misclassifying these relationships can come with penalties. It is one of those civil breaches that we discussed before. It's important to always have a contract in place, and again, that's something we can assist with the HRA cloud, but we'll get into that a little bit later. So essentially, now I've gone and told you all the risks that essentially face your business, and again, it's not to scare you, it's just this knowledge can provide you with a little bit of information to know what to look for potential areas of risks in your business. So essentially, HR Assured offers a very holistic management solution. There's two primary facets to that. On the one hand, you're looking at the telephone advisory service, so you'll call up and you'll either get to speak to me, and I'm sure you're sick of listening to my voice by now, but you'll either speak to me or one of my colleagues. And again, anything that I've talked, anything I've discussed today under the Fair Work Act, anything under Modern Award, any contracting issues, just call us up and we're more than happy to discuss these issues with you. The secondary part of what we offer is a HRA cloud. So it's an online platform that provides you with all your templates for your employment contracts and your policies. So we'll go through that a little bit. So your telephone advisory service, again, if you're really unfortunate, you'll get stuck with me on the phone again. But your telephone advisory service is there from 9 a.m. to 5 p.m. Australian Eastern Standard Time. Some parallel service standards is an average response time of less than 15 seconds. Again, my colleagues are very, very talented and they're experts in employment relations. And not only will we be able to advise you on, obviously, certain HR issues and risks that may face your business, but we can provide sort of strategic solutions to get around some of these issues that are quite challenging in the fitness industry. Because we do a lot of work in the franchise sector, we do have a deep understanding of that. The scope of the telephone advisory service, and again, essentially it's touched on everything that I've discussed today, but advice on certain areas of the Fair Work Act and the Fitness Industry Award. So how to correctly classify an employee. So when we're looking at those levels of, like that question we had about direct supervision, we can provide a little bit of guidance about where you're going to classify your employees, because those classifications are directly linked to the pay rate scales. It's important to get those right. Advice on contracting arrangements. I think I've talked enough about contractors. Step-by-step guidance through the management of employees. So what's really great about this service is you have an employee who's calling in sick every day, and it's incredibly frustrating. You don't know what to do, and you know that there are very strong protections under the Fair Work Act, but you don't know how to deal with that. Well, if you call us up, we can actually take you through each step and call us back each time on how to manage these issues with your employees, or if somebody's not performing well enough, or there are really bad conduct issues, something terrible happens at the Christmas party. All these are reasons that you can call us up and go, what's the best way for me to deal with this employee, to obviously limit the risks under the Fair Work Act and the Modern Awards for your business, but also we can just provide step-by-step guidance to talk through the risks facing your business. We also understand the obligations under work health and safety legislation. And again, providing that best practice advice. So not just saying, here's the law and this is how it is, but actually providing you with step-by-step solutions to solving your problems. And that's why we do encourage you to call regularly. Now, the HRA Cloud is the other half of the offering from HR Assured, and it's a very comprehensive service. So it's Australia's leading leading cloud-based HRIS system. So it provides an end-to-end solution to manage employees, work health and safety, and your contractors. So some of the things that it includes, so you've got your employment contract templates, which is very, very useful. There are also contractor templates on there as well. Guides, so again, whilst you have the telephone advisory service, there's also step-by-step guides for conduct management, going through a genuine redundancy, employee management, step-by-step guides which provide you with information on how to deal with each step, what information you need to get to move on to the next step, and also templates for instance, a letter to invite an employee to a disciplinary meeting. We have all those on the HRA cloud. It also provides you with a one-stop shop for your electronic records management. So once all your employees are in there, you can go and look at the history of the relationship between the employer and the employee and identify any issues. It's self-service, so again, it has these step-by-step guides which you can follow, which are quite clear and quite comprehensive. And the other thing it has as well is online performance appraisals. Again, so you can just essentially follow the relationship. So when you log onto the HRA Cloud, this is what you're going to be looking at. Now you've got those three purple boxes at the top, so your pre-employment, your employee management, and your termination. Essentially, these will all, if you click on any of these purple boxes, they're going to provide you with step-by-step guides. The pre-employment is essentially where you're going to go through your hiring checklist, and as well go through sort of any steps you need to take, including developing the employment contract, which we do have templates for. The employee management tab, again, is providing those workflows to go through your performance appraisals, to go through conduct or performance issues if they're not performing well enough, and again, to adhere to your consultation requirements. So you'll click on that tab and it'll give you a bunch of options, and it's just an assistance to help you manage your employees. The final tab is that termination tab. So again, it provides you with best practice advice to limit your risk when you're going through a dismissal, because there are situations obviously where you need to terminate the employment relationship for various reasons. But by taking a few steps, you can really limit or essentially eliminate the risk of an unfair dismissal claim. You know, there's certain steps. If you ensure that you invite a support person, provide them with 24 hours notice of the reason of the meeting, give them a valid reason, give them an opportunity to respond. By taking all these steps, you're removing any risk from an unfair dismissal claim. It also provides pay tables, plain language guidance on the Fitness Industry Award, if I haven't been very clear, and if I haven't, I apologise, and employment policies and procedures. Another facet, so on the right-hand side, there's also, if you look at employees, below employees, there's a contractors tab. And if you click on the contractors tab, you're going to get to this, you're essentially going to get to this screen here, which provides you with contractor engagement, contractor management, contractor termination. It's essentially the same as your employee tabs, but it's tailor-made specifically for contractors. So a couple of things it has. It has a contractor agreement as opposed to an employment contract. So we'll outline the obligations under the contractor agreement, but it's a very different contract to what you have during an employment relationship. One of the really beneficial things it has, and it's your first stop guidance under that contractor engagement tab, is it has what's called an ICA bona fide test, so an independent contractor agreement test. It's a little Q&A, essentially looks at some of the factors that I went through earlier with the contract relationship and identifies any risk in the relationship. So you know, if you're not really sure, you can identify that there are some risks, and then you can call us up and we can discuss the matter to talk about how we can eliminate that risk. Again, contractor management, particularly with your work health and safety, that's there. And there is also that termination tab to when you want to terminate the contractor agreement. Just moving on to the HRA Cloud, so your technical support, so you have your knowledge base. So it's an online platform where franchises can find readily available answers and FAQs regarding any aspect of the HRA Cloud. There's a blue button, so your help button in the bottom right-hand corner of the HRA Cloud. Excuse me, sorry. Which just if you have any issues, you can click on that and that can provide you a little bit of guidance. We also have client experience. So client experience is on 029083 0083, and they're going to answer any of your technical issues. If you're not sure about, if you're not happy with the formatting of your contracts or certain technical issues with the HRA Cloud, they're going to be your first port of call. if you do have any sort of technical issues. And the same with an email address there for technical support, support at HR Assured, and again, standard 3-hour first reply rate. So now we get to the pointy end of the presentation, essentially, which is the benefits. So obviously I've outlined some of the risks that are facing the fitness industry, and I do recognize, obviously, the challenges are there. But the benefits in utilizing the HRA Cloud in conjunction with the telephone advisory service, so we call it TAS here, it allows you to rest comfortably knowing that we're going to give you advice to ensure that you're compliant, but you're also going to have the best practice employment relationship. So we're going to employ those strategic solutions. We're using technology to remove some of those transactional issues, so to make sure you're going through all the right steps when you're going through a disciplinary process. Most importantly, it's implementation of a robust defensible position. Essentially what this means, and what's really important, is it gives you something to say to Fair Work if they ever come and have a complaint, or they go, we have this issue. You can go, well, look at all these steps that I've taken to ensure that I do run a compliant business. Here, you can call up my advisors and discuss with them all the advice they've given me on this, because we know that we're obviously going to give you compliant advice as well. It just gives you a very strong position to sit there and quite clearly go, I've taken all these steps to ensure my business has been running correctly. So it puts you in a much stronger situation. Again, one source of truth for information, so calling through and asking our telephone advisory service for various information means you know that you're getting the information from a trusted source, and you know that it's correct. Most importantly, it allows business owners and managers to have oversight of their operations. They can essentially outsource the HR component of their business to both the HRA Cloud and the telephone advisory service. You don't need to hire a HR person to deal with these issues. You can just call through and we can discuss any issues that you may have. So now I'm going to open the forum up there to any questions people might have. Again, if you could just send them through on that little chat box in that bottom right-hand corner. I know it's been a lot of information in a sort of a short period of time, and I do apologize that it can be a little bit overwhelming. But if there are any questions currently, flip them through, and I'll see what I can do. Like I said, if they're quite specific or they require sort of specific advice or quite complex advice, what I'll do is I'll pass the questions on to the telephone advisory service, so my colleagues or myself, I'll give you a call and we can actually discuss it in a little more detail. But if anybody has any questions now, just looking through on that chat box. Do you need to pay contractors more? Okay, so the first question we've got is, do you need to pay contractors more on public holiday? No. Contractors aren't bound by there's obviously some, there are some provisions in the Fair Work Act that apply to contractors. The Modern Award only applies to employees. So those penalties for overtime, things of that nature, only apply to employees. Contractors are not an employee. Having said that, a genuine contractor should be in a position to negotiate their rates of pay because they're running their own business. So they're selling their services for a price that they believe is the correct price. If you tell a contractor how much you're going to pay them, it's less likely to look like a genuine contractor relationship. So on a public holiday, a contractor may turn around and go, yep, I'm happy to run your group class on these 3 days on these specific days. That's fine, but I'm going to do it for twice the price, or maybe 1.5 times. But it's up to them to negotiate. As they're a contractor, not an employee, there's no obligation or no entitlement for them to receive extra pay on those days. It's just an agreement between you and the contractor. So hopefully, Victoria, that answers your question on contractors. If anybody has any other questions, I'm happy to sort of answer those general questions now. Otherwise, if anyone has any major issues, I'll just go through the numbers. So we do have brand-specific numbers just so we can direct the calls to the most appropriate advisors. So if you're calling from Anytime Fitness, the best number for the telephone advisory service is 0290830092. So again, that number for Anytime Fitness is 0290830092. The number for Massage Envy is 0290830094. The number for Orange Theory, 0290830093. And the number for Extendbar is 0290830095. I'll be sure all those numbers are attached to the email I send you after this. And again, I will send all of these. Slides out to you. So I've just got another couple of questions. So yeah, just outlining the contractor relationship. Obviously, it is a very grey area, ultimately, because the determination of the relationship is very clearly on the relationship as a whole. So you can't determine what is or is not a contractor relationship. What I will say is the advice that we can provide will help you mitigate the risk in the idea of a contractor relationship. But if you do have obviously specific concerns, of course, call through and we're more than happy to discuss that. All right, well, I hope, as it appears there's no more questions, I do hope that has provided you with a little bit of information, obviously in regards to the challenges facing the fitness industry, but also where we can help. I understand, obviously, that the primary concern, a very big concern, is the contractor relationship. Given that it is a multi-indicia test, we are experts in the field, and we definitely hold ourselves out to be. So if there are genuine concerns about that, we always ask you to call through and get specific advice for your specific situation. Because every situation is different, that's generally how we sort of try to answer those questions, because every situation is factually different. You're going to come up with a different answer for every question. So we do advise, if you do have any issues, call through on the telephone advisory service on those numbers I provided you. Again, I'll provide them to you with the slides in the email once we finish up here. Thank you very much for attending. I hope it wasn't too boring for everybody. But if there are any concerns, again, call through to our telephone advisory service, and we're happy to have a discussion.